Welcome to the Sam the Answer Man podcast. For 30 years, Sam Ventola has been an attorney, hearing officer, professor, and mediator. Now he's here to answer your legal questions. Sam the Answer Man, law made simple. Here's your hosts, Sam and Gina Ventola.
Hey, podcast fans. Welcome to the Sam the Answer Man podcast. I'm Gina.
And I'm Sam.
And we're so glad you're here. So, Sam, you being a lawyer for 30 years, can we talk about landlord-tenant disputes and how mediation fits into that?
Sure. I mean, when I first started mediating, the experience I got in the very beginning was being a volunteer mediator at Denver County Court. And 9/10 of what I heard there were landlord-tenant mediations. There were cases where the landlord had brought and the parties had come to court in order to have a hearing on whether or not the tenant was going to be evicted from the property. But before that hearing took place, the judges would always send the parties to mediation before mediators like me, who would try to get them to resolve the dispute. And in every single case that I did, I actually got the issue resolved because it makes sense to resolve those disputes in mediation. And now that I'm mediation practice, a lot of the mediation that I do in commercial cases on commercial leases. And again, as with all of my other commercial mediations that I've done, I've been able to resolve every single one of the landlord-tenant disputes in mediation without having to require further court action. So there are reasons why mediation makes a lot of sense in landlord-tenant disputes, and it's really a way to go, whether it's a residential or commercial lease dispute.
Do you find in most, and it could be residential or commercial leases, that they have a mediation clause in there?
Not most leases do not have mediation clauses, either commercial leases or residential. There are some, but most do not. However, when, particularly in residential cases, when you go to court, the judges will require you to do a mediation, and the context of the mediation is that you're already there for the hearing, and the judge says, well, instead of going to a hearing, I'm going to send you over there to do a mediation, see if you can work it out. In the commercial lease context, again, judges in most cases will require the parties to engage in mediation at some point before trial. So in this case, it'll be not right before trial, but maybe a few months before trial, or if the parties are smart, very far away from trial, very close to when the dispute began. Typically, there will be a mediation and hopefully resolved depending on how skilled the mediator is.
So you mentioned in commercial that to have the mediation sooner rather than later.
It's always not just on landlord-tenant disputes, but any commercial dispute, or really any dispute. It's always better to try to get mediation done early rather than late. And the sort of tradition of the attorneys is, yeah, we'll do a mediation, but we'll do mediation very late in the day by the deadline that the judge gives us, because first I need to do a lot of discovery, I need to get a lot of information, I need to take depositions, I need to file motions. And when you do that, you've basically lost a lot of what you gained by mediation, because you've spent a lot of money on litigation. And so I think it makes a lot of sense to go at these things early, because you may well get them resolved without the cost of litigation, which again I have done in all the commercial cases that I've done.
So with that being said, are most landlord-tenant issues because of unpaid rent, or are there reasons why they're unpaid rent other than lack of money?
Well, I mean, I will say that at least a large factor in a lot of cases are unpaid rent, and a lot of times the reason for that is that the tenant doesn't have the money. Now, having said that, very often the tenant will say, well, it's not just that I don't have the money, there are these issues, there are these failures of the landlord on the lease, and that is why I didn't pay. It may or may not be true, and maybe the tenant didn't have money. But the lack of funds of the tenant, both in residential and commercial leases, is often a big issue. The landlord will come in and say, here, my lease, I'm entitled to this amount of money a month. I didn't get it for this number of months. I'm entitled to this. Plus, I'm entitled to enforce the lease into the future. And so I want all of this rent. And sometimes that's just not practical, because the real reason why the tenant, defaulted on the lease, maybe because the tenant just doesn't have that kind of assets. And normally tenants, both in a residential and commercial lease, have some incentive to maintain the payments, because having to move out is a pain, having to relocate is a pain, either your residence or your business. So if there's been a failure of that, it may well be a problem with lack of funds. And so that's something you have to accept and look at in mediation is, if I'm not going to be able to collect, does it make sense for me to spend all the money to go to court, get a court judgment? Meanwhile, I still don't have the property back. And then by the time I get a court judgment, I have a piece of paper saying they owe me this money, but I can't collect it. So that's something that needs to be considered when mediating either a residential or commercial dispute is, will the tenant really have the funds to pay the full amount? And if not, what arrangements can be made?
And so what I'm hearing you say is something more along the lines of, do I, as a landlord, or a property owner, do I want to throw good money after bad?
That's one of the things that you have to consider in mediation. And one of the reasons why you want to take on mediation early is that it is going forward. We call it in mediation, we call it the best alternative negotiated agreement. Is my BATNA really that great if it involves me spending a bunch of money going to court and ending up with a judgment, best case scenario, that I may well not be able to enforce.
I see. Well, that's some great information. So if a commercial landlord or property owner really wants to pursue mediation, what should they think? Who should they seek out? What qualifications?
Well, again, you want somebody who's skilled as a mediator, but also skilled in the litigation process, who's done from the litigation standpoint, done cases involving leases, and if it's a commercial lease, commercial leases. So I would recommend having a mediator who's experienced in commercial litigation, specifically commercial leases. And then because they're ones who will be able to help you out with knowing what you face. For example, you may think that if you go to court, when you have a hearing set on X date in order to evict the tenant, that you're going to get possession of the property on that date. But an experienced litigator will be able to tell you, you probably will not. In fact, all you get is another piece of paper which says, is an order to the sheriff saying, this landlord is entitled to his property back. But there's a whole lot that has to be done after that. The sheriff has to get around doing it. You have to remove the property of the tenant if there's any property there. That may involve a very significant expense. You have to hire movers to do that. So, you'll want a mediator who understands what going forward with one of these cases looks like. And not somebody who's going to think, well, if you succeed in the eviction hearing, you're going to get the property back that day, because you're not. And that's an example, not just on leases, but any kind of commercial litigation, is you really want to have a mediator who has been there and has seen, how this is really going to play out for you if you continue. And, a lot of mediators are not attorneys, and there's a place for them, but I don't think in commercial litigation for this reason. A lot of mediators are retired judges who not only are a lot more expensive, but also they only have seen these things from the perspective of a judge. And the judge, is in a position where he gets what he wants when he wants. You probably want to have a mediator who knows what you're going to be facing, or what your attorney is going to be facing if you have to continue to litigate.
There you have it. That was a lot of information. So landlords, tenants, you're looking for a qualified mediator who will not only help you resolve your dispute, but offer some instruction on the law, right?
Right. A lot of mediators will be the non-attorneys or judges or attorneys will tell you As a mediator, I can't give you legal advice. I don't agree with that. I think that a mediator who is an attorney can give legal advice, and in fact should express a legal opinion if it's going to help the parties understand what their rights and liabilities are, and it's going to help resolve the case that way. And so, for example, for that reason, I can mediate cases where one or both of the parties don't have attorneys. I can explain the law to them, and maybe they'll never have to hire an attorney and incur the expense of having an attorney look at the case, because I'll look at the case for them in mediation. So that's an advantage of using a mediator who's willing to give legal advice.
And that kind of helps expedite the process, right?
Right. Yeah. Again, because with the idea of doing it soon. If you go to an attorney first thing who's not a mediator, and you say, I have this problem with my tenant, I have this problem with my landlord, the attorney is going to, and I'm not saying they're being dishonest about this, but they're going to believe that the best thing for them to do is to go to court or write a bunch of threatening letters or do a bunch of research or take a bunch of depositions or issue a bunch of discovery, a lot of things that are going to cost you a lot of money. And that may or may not be necessary. It may well not be necessary. You can for a small fraction of the cost of that, you can first go to mediation, see if you can resolve it. The process is completely confidential. It's completely voluntary. If you don't like the offers that you end up with in mediation, you can say no. And it's really only cost you a small amount of money compared to going down the road of litigation in the first place.
But we like litigators. We like attorneys.
And we are litigators. But again, litigation is not a business-like way to resolve business disputes. It is, I've said this before, there was a Duke University study that showed that in litigation, the parties end up paying more for the litigation than ends up getting won in the litigation, either through settlement or judgment. Litigation is not a rational, reasonable way to resolve disputes, not when mediation is an alternative that's out there and, again, for a very small amount of money, can resolve the thing.
Well, there you have it. Sam, thank you for that helpful information. If you're a business owner, if you're a landlord, if you're a tenant, and you're looking to settle your dispute quietly and efficiently, you can reach out to Sam at samventola.com. You can also go to our website, ventolamediation.com, and schedule your mediation right there online. You don't even have to call anybody. It's just right there online, and you'll see the dates and times that Sam has availability. Podcast fans, we haven't left you out. If you want to click subscribe down here at the bottom where it's on our YouTube channel. You can also, audio fans, check us out on iTunes. We also are on Instagram, where we post some of the snippets of some of these podcasts.
And link to the full podcast.
And link to, well, we can't on Instagram.
Oh, okay.
Instagram is kind of funny that way. They no links allowed.
Oh.
They just want pictures and the hashtags.
You can tell how much I use Instagram.
And we're really, that's okay. You can also find us on Twitter at samtheanswerman.com. And last but not least, we're on Facebook. So check out the Sam the Answer Man page.
Where you will find links to the full podcast.
Well, you will find links to the full podcast. So thank you for watching. Thank you for listening. And until next time.
If you would like to discuss your legal issue with Sam, please contact Ventola Law at 303-864-9797 or check out our website at www.ventolalaw.com. Ventola Law, mediation and legal representation at an expert level.